Ist das Märchen, es gäbe künftig kein Moria mehr. Wenn es nicht so traurig wäre, müsste man darüber lachen. Denn ganz klar ist, dass das vorgeschlagene Asylgrenzverfahren ohne Hotspot überhaupt nicht machbar ist. Die fünfte Lüge ist, es gäbe eine Win-Win-Beziehung mit
that there would be a win-win relationship with third states. We say these are dirty businesses at the cost of refugees and third countries. But the main lie, which the whole construct of this pact is based on, is the lie that 2/3 of all asylum seekers along the borders would be economic refugees anyway, irregular refugees that wouldn't have any right to asylum anyway. And with this basic lie, mass deportations are being justified. The aim is to have a deportation officer who also coordinates this. So deportation, deportation, deportation. This real obsession is embodied in this pact. Such a pact has to be avoided à tout prix. We're going to get in touch with all Democrats that want to take a single step into that direction. And let me say, last but not least, that the individual right to asylum is a human right. And after 2 world wars, we fought for this. After 2 world wars, where we already dealt with asylum. So it also relates to the ethical integrity of post-war Europe, and therefore also our ethical integrity. In the European Parliament, the left party, the left group, made an alternative proposal, which we want to discuss today, which we want to promote, and which we want to use for our negotiations in the European Parliament. And that is also why we have decided to organize today's video conference. We need this exchange, and we need an alternative proposal to this pact. Dear friends, we have organized 2 roundtables for today. 2 roundtables that have been tabled, so to speak. We're going to be discussing 2 big topics. And I'm going to switch back to English now.
Touch us about pact implementation. We have time until 11:15, and we have 6 speakers. I hope Milena is also on board. We will see. And we start with David Conran-Smith, Senior Counsel, CCBE, European Lawyers in Lesbos. Welcome all our speakers. We start with you, and let me say again, we have only 7 minutes time. Please look that we can keep in touch it, and please start, David, with your contribution. Keep in touch it.
Thank you very much, Cornelia. At the beginning, I would like to thank the European Parliament's Left Group for the very kind invitation to speak to you once again today, and also to express my thanks to Amandine Bach for her very impressive organizational skills. Some of you may have seen me present on the topic before, but just to repeat, I'm here as chair of the CCBE Migration Law Committee. CCBE represents the 1 million approximately European lawyers from 45 countries. And also I'm here in my capacity to speak on behalf of the European Lawyers in Lesbos organization. That organization is the only body on the island of Lesbos that focuses on providing legal information, practical support, and tailored legal advice at first instance, and has given it to 11,000 asylum seekers since 2016 through more than 200 volunteer lawyers from all over Europe. It continues its work today through the pandemic and through the recent terrible fire in the Moria Center, which you're all aware of. And I'm going to just boast for a minute and say our project has just been awarded the 2020 Rule of Law Prize by the Union Internationale des Avocats, the International Union for Lawyers. As the first speaker today, I'm going to begin with the first measure in the new pact, and that's the proposal for the pre-screening regulation. And as an organization, we have very serious concerns that the current practices in the hotspots have not been learned from by the European Commission, and that the pre-screening regulation, if adopted, will lead to further confinement and miserable conditions for new arrivals into the European Union. As you know, it covers all third country nationals arriving at the borders of the European Union or found within the European Union where they are effectively arriving on an undocumented basis, and they will have to undergo certain checks: health, vulnerability, identity, and security. 4 areas of real concern for your committee. First of all, the time limits. We think that the time limits are unworkable. It's 5 days for the screening process, except in exceptional circumstances. And it's 10 days maximum where there are very large waves of migration arriving. And our experience in Lesbos is that these time limits are impossible to comply with, that they will lead to concentrations of people in what will essentially be closed detention centers before the procedures are accessed. We're also concerned about the assessment of vulnerability in Article 6. The measure is completely unclear as to what legal assistance will be available to those individuals, especially in the context of age assessment procedures. There is a wide variety of age assessment procedures in the member states. They're not harmonized. Some of them are medically invasive and possibly degrading, depending on the member state concerned. We have concerns in relation to how this will apply. The third relates to the duty to provide information on how to apply for asylum in Article 8. And the difficulty that we see there is that this leaves too much power and discretion to individual caseworkers in the member states. It says that they must provide that information where there are, and I quote, indications they may wish to apply. No one knows what an indication is in an individual case. And we say that this is not a discretion that should be conferred on national caseworkers, but the information should be provided to everyone who arrives. Finally, we have a concern about the monitoring of fundamental rights at the hotspots, in particular in Article 7. Too much discretion again for the member states, and the role of the Fundamental Rights Agency, which will issue guidance, and that's its role, is insufficiently strong. That there are clear concerns in relation to that. I'd like to then move on to a global concern we have in relation to the whole approach of the Commission and how it approaches the pact. The proposal essentially aims to repackage the current failed hotspot policy and will, we believe, lead to I suppose the forced containment of thousands of migrants in administrative centres at the EU borders in the member states. And as you were aware, for example, in Moria, there are approximately 13,000 people at the moment, most of whom were left homeless as a result of the fire. And this proposal will, for the very first time, make concrete in secondary legislation the concept of being legally on the territory of the European Union, but not in the territory of the European Union. Now, that's a very difficult concept to explain for the Commission, and it's more difficult to understand for anyone who has any interest in human rights. This is a form of legal extraterritoriality. President Trump has outsourced asylum on the southern border to Mexico. You stay in a holding pattern in Mexico to see whether or not you are eligible for asylum. We're not doing that. We're creating these new borders, extraterritorial centers, where people will be confined because they will be closed centers in a manner that we would not have imagined possible, either from a legal perspective or indeed a social perspective 10 years ago or even 5 years ago. The Court of Justice,
David.
yes, I'll finish now. The Court of Justice in Luxembourg and the Strasbourg Court in two recent cases, FMS in May in Luxembourg and NT in Spain in Strasbourg in February of this year, have identified that confinement in this particular context is detention as a matter of law. And that's important. So therefore, the Commission is asking the legislature to adopt a new detention procedure. And the Strasbourg Court, just to finalize this point, says that the principle that domestic rules governing border controls must not render ineffective the rights guaranteed by the Geneva Convention and its protocols. And we say the proposal is legally deficient in relation to this. It's unnecessary, and it clearly undermines the fundamental right in the Charter to apply in the EU for asylum. Thank you very much.
Ja, vielen herzlichen Dank für diesen wichtigen Beitrag.
Thank you very much for this very important intervention. We'll certainly get back to it regularly in our negotiations. But perhaps now we'll move on to the next speaker. We look forward to Ima Vasquez, representative to the European Union from MSF Médecins Sans Frontières. You have the floor.
Hello, good morning, and thank you very much for inviting MSF to this discussion. I am going to repeat a little bit what has been said, but I will go quickly and then I will try to bring some practical examples of what MSF as a medical humanitarian organization working on the ground witnesses and does. So in terms of the new path and the old path or no path, I mean the measures, the policies that are today being applied, it has. I mean we call it we call about the wrong assumptions that have been made and that are still there and that are consolidated year after year, measure after measure, and new now in the new path again. Cornelia was referring about the lies. We call it the illusion, the illusion that it's possible to stop people from coming to borders and that it is possible to do it in a right, respectful manner. Of course, the illusion that it's possible to triage the people and quickly decide who is entitled to protection and who is not, and that this is also, as David was saying, possible to be done in a right, respectful manner or in respecting the refugee laws, and then the illusion that people can be returned very quickly. That's why we can accept the fiction of people containing Greek islands, because it was supposed to be something very quick and clean, and now with the new fiction of this border extraterritorial that we don't understand exactly what it is, as David was mentioning, and that we will see. So and of course, or even with what we saw lately in Greece, it was also that there was the illusion that people will return voluntarily from Greece, for example, to IOM and so on. So all this is with the fiction that it is right, respectful, which is something that fundamentally impacts us as a medical or as a humanitarian organization, that we keep saying that this is right, and we keep saying that there will be new measures that will be taken. In this case now is the new path that will correct, and yeah, it will improve, but this is for 5 years now. It has not improved, it only deteriorates, and this I mean, we have been part of the evidence that has been provided to justify this. Now, I would like to just speak a little bit about the Central Mediterranean and search and rescue and Greece, just to keep in practice the ideas, no? So in the Central Mediterranean, first there was, well, we all know the Mare Nostrum, so it was decided to stop dedicated search and rescue capacity because it was a pull factor. But then it was, with the same argument, it was justified that even the operations of Frontex and Sophia also, yeah, I mean, to instruct them to navigate far away from the SAR zone, just in case that they have to do a rescue and to avoid these rescues to happen. But then it was also justified, and this is European Commission action plan of capacitating the Libyan Coast Guard. It's not the fact of capacitating the Libyan Coast Guard, it's to capacitate them urgently to cover an extended or expanded SAR zone that they knew they will not be able to cover, and also to coordinate. And this we have documented that broadly, and MSF and the rest of these organizations. So, and this was again as a right respectful policy, which is not. And then of course the criminalization of NGOs, and this is something where we think that all support is needed for all the organizations doing SAR and for other organizations also working. So the new path includes a recommendation that states that the NGO SAR capacity or SAR activities should not be criminalized. But this recommendation is very weak. And indeed, it's a recommendation because it's a recommendation to start with, because it doesn't say anything that is not already applied by international law, for example, and because it is based on the facilitation directive, meaning of accusing the NGO search and rescue to collaborate or collude with smugglers. However, what is happening now, and this will be discussed after, is that this criminalization is happening now with new excuses, and in this case, is the excuses of safety of navigation. But I will not go into this because it will be explained later. So these are points in the search and rescue. In the Greek islands, I mean, what else can be said? We don't know anymore. We have been for 5 years documenting, recommending, explaining. Nothing improves, only there is. I can just say that for us, 2020 was even the worst of the 5 years in the work that we have been doing there. So there are still reminding there is 19,000 people. When the Eudarchy was announced, it was supposed to be an extraordinary temporary measure that will soon end, and today we still have 19,000 people. You mentioned the detention, David. I will say also this is an indefinite detention, which is even worse than the formal detention, because you don't know when and how you will be able to get out from this island. So this is also a component that could be discussed. And then also I wanted to, something which for us is important, is how the COVID pandemic has been misused also legally to justify confinement measures that were completely non-proportionate and indiscriminate, and against the European guidelines, the ECDC guidelines, and also, of course, international WHO guidelines. So these are concrete aspects where I think it's important to follow up in the details to see with path or without path, with whichever measure is applied. One of the difficulties that we face is that most of these measures are not based on any international agreement or legal. It's just sometimes administrative measures. So how we can act to protect ourselves and to protect the people in these regards. So. Yes, and for example, something that happened to us and which we think is just unbelievable is that our COVID clinic was closed in Lesbos when it was working, and it was closed and it was not replaced by any.
1 minute, Inma.
Yes, I have it. Okay, so just to wrap up, a very important aspect to follow up of the new path is the criminalization. So the recommendation is not enough, and there is another recommendation in the path of cooperation between member states in regards to safety of navigation that we think is problematic and can bring additional obstacles to search and rescue. And then, of course, that nothing will improve if the assumptions that have been made in general migration policies are not changed. So this is a denial that Europe is facing, a denial of by discussing on solidarity, we are just hiding a reality, which is that Europe is not respecting fundamental rights and is not able to provide the just most basic dignity with people arriving in our territory.
Vielen Dank, Inma.
Thank you very much, Inma. Thank you very much also for the work you're doing there since many, many years. You are at the very top front, as we say, and we of course work together with you very closely. And it's extremely important that you are there in order to give us a real insight as to what is happening. Well, thanks a lot. And we are certainly going to continue cooperating also in light of the negotiations and discussions that will be had. Minos Mouzarakis is next, Legal and Advocacy Officer, Refugees Support Aegean. Also very important. I will now give you the floor. Do not forget, you have 7 minutes.
Thank you very much, Cornelia, and many thanks to the Left Group for organizing today's discussion. Now, our discussion this morning is about challenging the Commission's narrative, which I find to be an absolute legal imperative in the current conditions of negotiating the pact. And I'll try to be very quick and to highlight 2 key issues and 2 practical examples as illustrations. Now, co-legislators are being brought back to the negotiating table by the Commission to discuss a big package of legislative proposals without any semblance of an evidence base to support the production of these draft laws. Focusing on the Asylum Procedures Regulation proposal as a prominent example, the Commission's explanatory memorandum cites an unpublished study on the implementation of the existing acquis, even though the Commission has flouted its own obligation to produce implementation reports and present them to Parliament, even following reminders from the House that this needs to be done as it is a legal duty under secondary EU legislation. As you might recall, the explanation provided by the Commission at the time was that we shouldn't be focusing on implementation with a view to avoid distracting the co-legislators from negotiating new laws. The second issue that is, of course, also crucial to those who will have to negotiate new legislation is that, as you also said, Cornelia, the political narrative of the pact is very often contradicted by reality. And I would even add that it is liable to mislead the legislative process. Very often the explanatory memoranda and the political discourse are contradicted by the legal provisions themselves. So there is a mismatch between what we are told the pact will be doing and what the pact actually purports to do. 2 quick illustrations from the procedural angle with main focus on the Asylum Procedures Regulation amended proposal. What we were first told by the Commission in its explanation behind the proposal is that the right to judicial protection is seen as a procedural loophole. So these are considered aspects that would hinder or delay procedures and should therefore be curtailed. Practical illustrations thereof are to be found in restrictions on the suspensive effect of appeals, meaning very concretely the right of people to be on the territory while the appeal is heard. The Commission says that this is only to be done in limited cases where the appeal is presumed to be unfounded. This is not true. Article 54 of the proposal includes such a derogation in other cases, such as implicit withdrawals of application or even withdrawal of an already granted protection status. Going further, the proposal on APR excludes second-level appeals in the border procedure. This not only raises constitutional questions in Greece, among other countries, where the right to judicial protection before a court would be interfered with in that scenario, but it is also tampering with very necessary safeguards against poor quality of decision making. Again, experience from Greece is particularly telling on how the first degree of appeal works in reality. Another example is to be found in a different instrument. The AMMR, so the new Dublin proposal, states in explanatory memorandum that the effectiveness of the right to appeal will be increased. And what the legislative proposal actually does is curtailing the scope of appeals and overturning years of CJU jurisprudence at that, and also introducing a derogation from suspensive effect. Second issue, to keep things as sort of quick as possible, what we also mentioned at the beginning, the fallacy in the promise of simpler and clearer procedures. The Commission codifies a numbers-based presumption of unfoundedness of application in Article 40 of the APR proposal. This is the so-called 20% rate criterion by which caseload can be accelerated or placed in border procedures. Now, not only does this circumvent the EU's own procedural framework for using such presumptions, again, as highlighted by the Court of Justice of the EU, but it also presents very practical problems that will make this anything but a clear procedure. It disregards the asylum lottery, because as we know, there is no consistent decision-making across the Union, and it injects significant legal uncertainty by adding elements such as significant change in the country of origin or a particular group of applicants for whom that 20% or lower rate is not representative. Now, as an asylum authority, those elements become difficult, if not impossible, to implement without proper legislative clarity. So I don't think that we will be going towards better, faster, and simpler decision-making. So to conclude, I think before even delving on the nitty-gritty technical aspects, we need to keep demanding transparency from the Commission and evidence. There are tools out there. The Asylum Information Database managed by ECRO is a very good starting point. And also organizations providing legal assistance, such as ourselves, are of course happy to keep feeding the process and assisting co-legislators in their work. Thank you very much.
Sorry. Vielen Dank, Milos. Wir werden also auf dieses Angebot auch zurückkommen. Ich glaube, wir müssen hier sehr viel diskutieren, was dieses Grenzverfahren.
So, yes, indeed. Let's bounce back on this procedure and talk about the different criteria. And we will also talk about the constitutional level. And indeed, it is problematic at the constitutional level. But thank you very much for this contribution, Minos. So the next speaker I would like to give the floor is Milena Zajovic. She's Advocacy Officer at Border Violence Monitoring and President of Are You Serious? Milena, you have the floor.
Thank you very much. Hello to all. So my name is Milena Zajovic, and today I represent both my NGO Are You Serious and the Border Violence Monitoring Network, a coalition of grassroots humanitarian rights monitors from border areas along the so-called Balkan route. In the past 6 years, our NGOs have recorded testimonies of over 12,300 individual pushbacks and numerous other human rights violations, both in border areas and deep in the European territory. In Croatia, where I'm from, we have recorded accounts of sexual assaults, dog assaults, electric shocks, mock executions, and shooting, in some cases with fatal or near fatal consequences, perpetrated by Croatian police officers and funded by the EU. We have repeatedly informed Croatian government and the parliament, Ombudswoman, United Nations, European Parliament, European Commission, and other competent institutions of such violations, but no effective investigation has been in place so far. On the contrary, the only change we have seen is rise in border police brutality, criminalization of our NGOs, and more EU funds to member states, such as my own country, as an award for the so-called border management. Today, we are here to discuss the new pact on migration and asylum, and honestly, it makes me feel depressed, if not defeated. I feel that way because when the new pact was drafted, we were promised a clean start, a more efficient system based on the respect of human rights and solidarity. Instead of a new start, we got a restart. Restart of contemptuous, subduing, and violent treatment of those who are still arriving in our countries in hopes of having a better, safer future for themselves and their families. Restart of triage centers such as the ones we have seen in Hungary. Restart of places such as notorious Moria camp in Greece. When presenting the new pact, Commissioner Johansson did mention solidarity. But it quickly became painfully obvious we are talking about solidarity among member states and not with people in need. She also mentioned compromise with member states such as Poland and Hungary, whose elected officials want to get rid of as many foreigners as possible so they could feel safe in their European homes or Brussels sex clubs, depending on the preference. For us living in Croatia, the compromise means our country would become a pre-triage zone, something we are already quite experienced with. Pre-triage is currently being done by the border officers, who usually ask you where you are coming from before beating you up, and the quick return is usually done over the green border, where people are being pushed back to the misery of Bosnian refugee camps. According to our expertise, in my analysis, I'd like to focus on some elements of the pre-triage procedure as envisioned in the new pact, and also the need for establishment of independent monitoring mechanisms, a topic also very familiar to us in Croatia. The new pact heavily relies on detention procedures, standing in contradiction to the EU legal framework. Although pre-screening detention centers are not formally detention sites, they do impose arbitrary limits on freedom of movement. After the pre-screening procedure, a person can end up in additional lawful detention. And this represents an extreme violation of the right to liberty and the principle that no person shall be detained for the sole purpose of seeking asylum. Additionally, as the part of pre-screening procedures, member states will be required to verify the ages of undocumented asylum applicants. As some speakers already emphasized, medical age assessment methods have often been criticized as unreliable or even without enough scientific basis. Additionally, the methods have often been found to be invasive or cause mental or physical harm to young persons. This is in direct violation, obviously, with the Convention of the Rights of Child that the Union has ratified. Reintroduction of the discriminatory safe country of origin concept, coupled with a 12-week deadline, makes me doubt if individualized assessments of claims would be possible, and whether remedies for effective appeal would be accessible for those rejected. Under the new pact, the proposal for pre-screening mechanisms foresees independent monitoring as an attempt to ensure fundamental rights are complied with. However, the monitoring is mentioned not only in the context, is only mentioned in the context of pre-screening procedures and fails to recognize the most severe violations, such as violent pushbacks, that are happening out of formal facilities, in the border areas, in accessible terrains. Here in Croatia, we did have an attempt at monitoring mechanism. It was organized by UNHCR and Croatian Law Center, and they were monitoring access to asylum procedures by looking into pre-selected police files of the minority of people who actually managed to enter Croatia and ask for asylum. Victims of pushbacks, often unprocessed and for sure not in Croatian soil anymore, were obviously not included in the monitoring. And we fear the new monitoring mechanism, if it would be connected to pre-triage procedures only, would again fail to recognize realities in the field and for sure would not prevent pushbacks as Commission claims. We are especially concerned by knowing that the test monitoring mechanism is currently being developed by the Croatian Ministry of Interior in collaboration with the European Commission. And I really wonder if I am the only one thinking what might go wrong if the ministry that is responsible for the most brutal pushback practices in the European Union would be tasked with developing a mechanism to basically monitor itself. Furthermore, it seems that the illusion of independence might be strengthened by inviting representatives of ministry-funded, dependent, and often silenced NGOs to be part of the allegedly independent mechanism. A truly independent monitoring mechanism should be led by national preventive mechanisms and the independent NGOs and funded directly by the Commission or through an independent agency. And this must not include only monitoring in pre-triage centers. It also has to include unannounced visits to police stations or border zones. It must see better cross-border collaboration in testimony collation from the affected population, as the ineffective mechanisms that are currently in place only take into account the cases of those who were able to remain in European territory, and therefore were not necessarily victims of unlawful practices. Such a monitoring mechanism would also benefit from an alarm system that could be triggered by potential asylum seekers in situations where their fundamental rights are violated. If
1 minute, Milena.
Thank you. Final sentence. If the EU fails to address the mentioned issues, we will have more death, violence, and humiliation at European borders, while Commission officials knit their socks in the warmth of their ivory towers, telling us they made a fresh start in asylum policies. Thank you.
Ja, vielen Dank, Milena. Spricht uns aus dem Herzen. Ja? Wir haben das ja gesehen, wie.
Thank you very much, Milena. And I do share your point of view. Indeed, the pushback practices seem to be legalized here, and it is a pity. I would like to recall that these pushbacks are tolerated by Frontex and even supported by Frontex. And therefore, we are quite doubtful, to say the least, about Frontex. And indeed, we need proper investigations. And I imagine that our Spanish colleague will be able to talk about it later on. Anyway, thank you very much, Milena. So, let me now give the floor to Sarah Prestiani, Migration and Asylum Program Officer for Euromed Right. Sarah, you have the floor. Thank you very much. I will speak in French. So first of all, thank you for the invitation. I think that we've been able to tackle some very important topics, and I would like to get back to a certain concept on this pact. We have talked about the fundamental rights, obviously, but furthermore, in these documents, we talk about proposals which are not practical at all if we have a look at what's happening on the ground. So let's start with the concept of solidarity. We can be quite doubtful when we talk about solidarity when we see the expulsion procedures and when we talk about the returnees. Secondly, there are many questions on the procedure. A third state can support a state which is under migration pressure for an expulsion procedure, and then if it doesn't work, someone can be transferred to a country with a sponsorship. This person will be detained for how much time? So there are many pending issues and many pending questions. Then, when we have a look at things, we have seen it in 2016, relocalization didn't work even though it was mandatory. So why would it work today if member states can choose between between showing solidarity on returnees and also on showing solidarity with budget-wise? Why would they choose to relocalize if they can choose to support Italy in funding coast guards to reject migrants? So there are many questions on these procedures. I will bounce back on another concept as well, conditionality. In these documents, there are very few legal means possible for access to territory, but we know that if we don't want people to die at the borders, legal means are necessary, but there are only very few. And furthermore, these legal means are conditioned to returnees' performance. So we condition the visa codes and the possibility to have uh, a visa to the norms for expulsion. This logic for conditionality has major consequences in this pact. And let me create a link between this and something else, because I think we need to wage these battles together. This view of the Commission is also there with the MFF, the multi-annual financial framework for 2021-2027. There we talk a lot about conditionality, and as a consequence, well, we can say that conditionality is omnipresent. Budget-wise and legal-wise. But let me now talk about pre-screening. If we take the example of a country such as Italy, well, there are many issues at hand. How do you want to do everything in 5 days' time? We are talking about people who have been tortured in Libya and people who have suffered during their traveling. How can we demonstrate everything in 5 days' time only? Then there are other questions about the safe spaces. We are recreating some spaces at the European borders, and imagine Lampedusa, there is no court there. So how do you want people to access justice? How do you want people to defend themselves legally? Let's not forget that today we are already in some kind of laboratory. When we have a look at the management of the situation in the Canary Island, no transfer is possible from the Canary Islands to Spain. And actually, we see that this procedure is similar to the one which is in the pact. And after these 5 days, a route should be planned for each asylum seeker, but there the choices are made depending not on nationality but on the recognition rate. So we made a simulation on the recognition rate with some European countries, and we are under 20%, and then it leads to an accelerated procedure. But this is possible for people from Egypt or Algeria. But today, an Egyptian asylum seeker would be in this fast-track procedure, and as a consequence, we are talking about countries where people's rights are violated, and this is a source of worry. Then there is the false concept about the safe third country. No third country is safe, and the Convention of Geneva bases itself not on the nationality but on a case-by-case basis. As a consequence, no country should be considered safe, and this concept is a bit everywhere in the new pact. Finally, let me talk about a simulation we made. If today we were to implement the pact, then Italy would have to increase by 7.5%, by 7 times 5, 7.5 times the amount of detentions possible. Then if we have a look at another mechanism, the crisis mechanism, well, then Italy will have to multiply by 50 the amount of detainees it can have. So if we were to apply this pact today, member states and the ones at the border will have to have on their territories, well, close to the border, detention centers with infinite places, no access to justice and no access to fundamental rights. This is the reality if this pact were to be adopted. And so I invite you at the European Parliament, and I invite you, the civil society, to fight so that these measures are not applied. And I also invite you, well, to fight budget-wise with the MFF in order, well, to reject, well, the adoption of these measures in budget. Thank you.
Vielen, vielen Dank, Sarah. Auch mit dir arbeiten wir schon sehr, sehr lange zusammen und
Thank you very much, Sarah. We have been working together for quite some time, and indeed we have witnessed all you just mentioned and what's happening with the pre-screening. And on a technical level, I cannot imagine how you want to have such a procedure in only 5 days' time. It's a joke. Honestly, I can't believe it. So these detentions then are so long for these people, it's unbearable. Now, I have to give the floor to the next speaker. While I would like to say more about this, but the next speaker is Céline Canta. And she's the author of Locked Up and Excluded, and she talked about the informal and illegal detention centers in Spain, Greece, Italy, and Germany. You have the floor, Céline.
Thank you very much, Cornelia. Good morning, everybody. Thank you for having me. So as has just been said, I'll present some findings for our report, Locked Up and Excluded, Informal and Illegal Detention in Spain, Greece, Italy, and Germany, which is published today by Migros and the Left Group. So it's a report that presents sort of an in-depth study of the administrative detention practices in these 4 member states. It has detailed information on the legal frameworks, the detention conditions, infrastructures. So I really invite you to read it. But today I will just present some key points of the report, and I'll try to draw on them to propose some broader conclusions regarding detention in the EU, because we believe that many findings of our reports apply beyond those 4 countries, and also regarding the so-called new pact. And these points will echo many of the points already made by previous speakers, whom I thank for their presentations. So in particular, our reports confirm what has been said here, namely that many of the supposedly new measures proposed in the pact are in fact generalizing practices that are already taking place in the EU territory, and which have highly detrimental effects on migrants and their rights. So the first point I want to make is that detention has been changing in all 4 countries under study in our report. We see important changes over the last few years in the way detention is practiced and governed. And this is true both for first arrival countries such as Italy, Greece, and Spain, which we've heard about today, but it's also true in presumed destination countries. And in our report, we study the case of Germany. So traditional detention, if I may call it like this, in pre-removal centers is still happening. But in all cases, in all 4 countries, we see that it is increasingly being complemented by unregulated, informal, ad hoc, or even illegal detention practices. And by this, we mean that more and more people have been locked up, either completely outside the law. So for instance, in Italy, rights groups have shown that detention in hotspots actually amounts to illegal detention, or by bending existing legislation. So that can mean, for instance, to systematize exceptional grounds for detention and use them routinely. Or in Spain, the opening of the so-called Center for the Temporary Assistance of Foreigners, the CATES, where about half of the people arriving to the country by sea are actually detained, and from where expedited removals take place, is actually happening outside of any specific legal framework. So as has been said, such unregulated and ad hoc detention means that migrants already appalling holding conditions that we have been denouncing for many years have become even more precarious. The second point I want to make is that those changes in detention practice depend on the country's position in the EU border control regime. So as I said, detention is changing across the board with a strong tendency toward informalization, but it does take different forms. It occurs in different kinds of facilities. It follows different rationales depending on which country we're looking at. Excuse me. So in first arrival countries, as we've said, which operate as border guards for the rest of the EU, detention essentially allows the authorities to filter migrants. And we've heard about it in a number of countries. It happens at the border. It's supposed to be fast to lead to quick return of unwanted migrants to the other side of the border. We've also seen that often it's not the case that it is that fast. And for various reasons, people get stranded at those border points. Such border detention is not happening in traditional pre-removal facilities, but in those informal sites, hotspots, border zones, police stations, sometimes container camps, and so on and so forth. In all cases, access to rights in such facilities or sites is limited, if not inexistent. Germany, a country where people presumably try to settle, detention is also generalizing in order to enable the deportation of non-wanted migrants to either other EU countries under Dublin or to third countries outside the EU. And this generalization can be observed, for instance, when we look at legislative change in the last few years. In 2019, a so-called Orderly Return Act was introduced, and it makes a number of hitherto illegal detention practices legal. So for example, in case of actually quite ill-defined emergencies, federal authorities in Germany are now allowed to detain people inside regular prison. And that's a practice that had previously been suspended by the European Court of Justice. So those are some of the examples of the informal and illegal use of detention that we look at in the report. And as I said, there are more detail in the report that you can consult. So my third point is, what have been the effects of such practices? So in all those cases, what we can see is that twin with deportation, which are also increasingly happening in illegal ways, and we've heard a very evocative example from Milena, detention plays a key role in EU migration governance. And its generalization acts as a deterrent for to-be migrants, as a mobility regulator, it filters people on arrival, and as a control mechanism, a disciplining mechanism for people who are already on the territory, people who live in this constant condition of detainability, the constant possibility of being detained for the purpose of deportation. Another effect is that informal practices tend to hide detention, and that's already been mentioned as well. So certain forms, certain sites of holding are not counted as official detention, and therefore they do not appear in official numbers and statistics. And when we look at official figure, we can have the impression in some countries that detention is decreasing, but in fact, it's rising in more informal and less regulated way, even further away from public scrutiny. And I think other speakers in the panel, again, have shown very poignantly the consequences of these repressive practices. So what we see is that the new pact will systematize those. For example, David and others have shown very well how the pre-screening measure essentially mainstream existing situations that have been proven to be dramatic. Moreover, it seems to us at Migre-Europe that by introducing yet another set of rules, the pact participates in this blurring of legal frameworks that adds to the possibility of arbitrary behavior, both by member states, which we believe increasingly pick and choose which rules they apply and when, and then on the ground, where migrants have long been the targets of discretionary measures by different border authority officials. So in 2 words, I'll invite you to read our reports, and I'll just conclude by saying that far from being new, the title is merely transforming existing bad practices into law, and that it needs to be opposed. Thank you very much.
Ja, vielen, vielen Dank, Celine. Vor allem auch für diese wichtige Studie, die ich wirklich nur empfehlen kann, die wir alle uns wirklich.
Thank you very much, Celine, for this very important study. I can only recommend it. Indeed, I believe it is important to monitor this very closely. And it will be useful to us in order to have more arguments, in order to defend our ideas, especially about informal and illegal detention. So thank you very much for this excellent report. The title is also very relevant. It's very valuable, so we will disseminate this study and in Germany and at European level. So dear friends and colleagues, we now have the possibility of asking questions to our speakers. We still have about 15 minutes for a Q&A session. So I can see a first question on the group. So in the section dedicated to questions and answers, I think you'll have the opportunity to read the questions.
Yeah, and this shows the flagrant failure of the policy of externalization, the management of migratory flows and external borders. And the question is, do you think that this policy is viable in the medium term, given that in these countries, Maghreb, Sub-Saharan Africa, a large proportion of young people are candidates for departure? Das war eine Frage aus dem Chat. Wer möchte sie gerne beantworten? Darauf eingehen, Sarah?
So this is a first question that we can see on the chat. So who would like to answer this question? Sarah or others?
Yeah, and maybe just shortly remind that what we are seeing now in Canary Island is exactly what we have seen in 2006 in Canary Island. So no, are not at all sustainable answer. The strategy now is to, from one side, try to reactivate the era of Frontex operation in Senegal, and to try to send back people to Mauritania, citizens not from Mauritania, but from other country, and to open a dialogue with Morocco. The Minister of Interior from Spain was in Morocco the last 20 of November to try to prevent departure, to increase the capacity of Morocco, as we clearly see also in Libya and Tunisia. It's quite the same strategy. The problem is that no one is asking why there is this increase of departure from Canary Island. First of all, that is strictly connecting how Morocco is increased border management in Ceuta and Melilla. So people are obliged to risk their life and to live more in the south from Morocco, from Senegal, from Mauritania. That is one reason. The other reason is also to look at fishing agreements with the European Union and this country who push a lot of people to lose their work and to take this risky journey. And third is also the economic and social condition also worrying by the COVID crisis. So no, the answer made by Spain and the European Union only externalize control, border control, and to sign readmission agreement is not a sustainable solution. And the fact that again we are in the same situation than in 2006 is a clear example and explanation that is not a sustainable solution at all, the externalization policy. And of course, that is also violating human rights. We have a clear violation of the Article 13 of the Human Rights Declaration. All people have the right to leave their country. Putting the Frontex boats in Senegalese water is violating these rights.
Ja, vielen herzlichen Dank zu dieser Frage.
Thank you very much for responding to this question. A second question has been mentioned in a language I do not speak, Lubia Florossi. Perhaps you could pose this question just to ensure that it is understandable to everyone.
Cornelia, maybe Imna can reply because it's on mental health. And
yes. I saw the question. Indeed, mental health is essential, and MSF. Well, we have the projects or the programs that we still have in the Greek islands. A big part of it is the mental health. Is also essential. It will be essential in Libya, but yeah, very difficult to work in detention centers on mental health. But yes, mental health needs to be considered much more strongly with very clear or more clear guidelines and instructions. But there are limits to addressing mental health when the fundamental problem that is creating or increasing the problem or making the mental health condition deteriorate even further cannot be tackled. So when you have a victim of torture or a victim of sexual violence that is in a horrible conditions, that you try to treat this person, but it goes again, or you have to send this person back despite the medication to the same conditions that are creating the problem, or that they make this person, for example, fear of its security, then you cannot address the mental health problem. So one of the main things or the main aspects that we have tried is to evacuate these people out of where they are in the case of the Greek islands, and to be able to receive the adequate treatment in safe and secure conditions. Sometimes it was in the mainland, but sometimes we were also advising the relocation out of Greece. So yes, a problem, a very big problem. It comes from the origin, and it is exacerbated because of the conditions that these people have in Europe. And of course, and then in Libya, yes, I mean, this is just the detention centers is difficult to describe. But then again, dealing with mental health, it's extremely difficult, and medication is not enough if you cannot find a solution of these people out of these detention centers. To give one concrete example, we had in a period, it was in 2018, we received MSF directly 150 victims of torture. It was clear about extreme violence and torture. They were escaping a clandestine detention center. It took us more than 6 months to manage to just take them out of the new detention center they were taken out. So they were escaping the clandestine detention. They were victims of torture, and they are taken to another detention center, also in horrible conditions, but this is an official one. It took us six months to manage to take them out of Libya to Niger, just to Niger. So to give an example.
Oh ja, vielen Dank. Das ist eine ganz wichtige Frage.
Thank you very much. It is a very important question that is often disregarded. We often speak about procedures, but not enough about mental health. And we have many refugees that arrive and are extremely affected in terms of the mental health. Allow me to ask two questions. Firstly, can that correspond with the Refugee Convention of Geneva as well as general EU law? How can this be undertaken, or could it be said that this is a violation? What could we do here? That would be my first question. And then my second question is something we haven't talked about yet, and that's relocation. I see no compulsory mechanism for relocation here. What I see here is strangely formulated sentences that have been tabled, and I'm worried whether we will have a relocation procedure that is also implementable. Perhaps whoever would like to could respond to these questions.
Could I perhaps jump in quickly on relocation? So basically, I think you're absolutely right. The way in which the solidarity provisions of the AMMR proposal are drafted are extremely permissive, because of course the main objective was to come up with a structure that would be easy for states to buy into and that would give them different options. One thing that we have slightly touched upon in the previous discussion, but I think is worth recalling, is that the mandatory character of relocation has had limitations in the past. We've seen, of course, the council decisions of 2015 resulting in very limited use, and also sort of arbitrary interpretations to limit the pool of eligible candidates. One thing that from our perspective is quite crucial to highlight is also the lack of transparency and clear criteria on how relocation should be working and which categories should fall into it. What we see in the proposals of the pact is an attempt at codifying the existing ad hoc relocation schemes that are currently rolling in Greece, Italy, Malta, where practice has revealed quite a bit of cherry picking on the part of relocation member states. Given that this is presented as a voluntary act of solidarity rather than a binding mechanism, it has been open to states not only to decide based on their own domestic political criteria who should be relocated, but also how to go about carrying out the relocation procedure. For instance, with interviews of asylum seekers on the soil of another member states, in procedures that are not transparent, where people don't necessarily have the requisite access to rights in EU law. So I think any discussion we have on the future of relocation shouldn't just look at numbers, how many people will be relocated for this to be useful, but also how do we do it? Because this is also a moral and a legal fundamental premise of relocation. Is this about choosing particular categories of refugees that we want, or is it about properly assisting both the member state in need and also taking a fair share of protection responsibility?
Perhaps I might jump in, if that's all right, in relation to the question of the application of the Geneva Convention, Cornelia, that you were talking about a minute ago. It does seem to me that on many levels that the pre-screening regulation is quite cleverly drafted. It's drafted, as you know, to provide for a maximum of 10 days in principle. And therefore, it is difficult to 10 days where there are, let's say, an emergency situation prevailing on a particular border, but 5 days otherwise. And in principle, it's difficult to contend as a matter of law that is contrary to the Geneva Convention. The issue here is that you could say that the Commission is giving a wink to the member states that in circumstances where there are large numbers of people, the deadlines will be pushed out, and it will only be on a case-by-case basis that it will be possible to establish as a matter of law that there has been a detention contrary to, for example, Article 5 of the European Convention on Human Rights, or indeed contrary to the Geneva Convention itself. And that's exactly what happened, for example, in the case of FMS, as I said, which came before the court in Luxembourg in May. So the point I'm making here is that there is certainly an argument from the Commission's perspective that the strict provisions meet with requirements that have been identified by the Court of Justice as regards detention and judicial protection. My worry, my concern is that on a day-to-day basis, when the member states begin to apply these pre-screening procedures at their borders, that the provisions will not be complied with, and that there will actually be no effective protection. So just to give you a practical example of that, it's something we're thinking about at the moment as lawyers, and that is what rules apply to lawyer-client confidentiality in these extraterritorial zones. Do the normal rules of EU privilege recognized by the Court of Justice, will they apply? What about the right of access to a lawyer for the purposes of age assessment or a vulnerability assessment? The concern there is that member states will push the boundaries, or certain member states at least may push the boundaries in terms of restricting access, causing difficulties on a day-to-day or operational basis, such that the strict rules are not being applied. Thank you.
Ja, vielen Dank nochmal. Und die letzte Frage geht nochmal.
Thank you very much. And the last question is once again directed at David, to be seen in the chat. It would be nice if you could briefly react to that question, after which we will have to close this first round. But it would be great if you could answer that last question.
Direkt auch an David gerichtet.
Directed directly at David.
Yes, I don't see the question, I'm afraid.
Okay. Moment. This is my question is to Mr. Smith. Another kind of pushbacks happen during the first registration about age. Many people allege that they are minors, but they are registered as adults, which cause them to lose many important rights, including family reunification and so on. From my experience at last in Lesbos, there is no any proper age assessment. Then the person has no possibility to prove his age and continue his asylum procedure, a single man in most cases. How is it possible to advocate and to act against this practice? Okay, bitte ganz kurz. Wir sind
Please
nämlich
try to be brief because we are basically running behind.
So insofar as that question is posed towards me, well, obviously our organization deals with that particular matter on a day-to-day basis. And as I said a little earlier, if one stands back from the specifics of this question to look at the approach taken towards age assessment and vulnerability assessment across the member states, the pre-screening procedure or proposal represents a missed opportunity in terms of introducing a harmonized approach taken at European Union level. Some member states use x-rays, other member states just use interviews. It really very much depends on a case-by-case basis. And of course, in Lesbos, there are real difficulties for the Greek Asylum Service in terms of the numbers of people that are there. And I have heard this complaint being made, there is no proper age assessment. But I think obviously on a local level, it's dealt with by the relevant organizations such as European Lawyers in Lesbos. But I do think it's a matter that the legislators should take into account in terms of a positive contribution that they could make towards the adoption of this proposal on the assumption that it is going to be adopted in one form or another, that some form of harmonized age assessment procedure be introduced.
Vielen herzlichen Dank. Wir werden auf diese Themen auf jeden
Thank you
Fall.
very much. We're certainly going to get back to these topics. I would like to thank all panelists from the first round. This was a very good start. And I'm going to give the floor to Kostas Avinatis for the second round. Dear Kostas, you have the floor.
Ευχαριστώ πάρα πολύ. Χαίρομαι πάρα πολύ που σας βλέπω. Κορνίλια, να είσαι καλά. Ήταν πάρα πολύ ενδιαφέρουσα αυτή η πρώτη ενότητα. Σημείωσα πάρα πολλά πράγματα.
Well, thank you very much. I believe that this first roundtable was extremely interesting, and I suggest we now open the second roundtable. And before that, I would like to make a comment. I believe the left group has had the opportunity to challenge and question the Migration and Asylum Pact. I believe we've had the opportunity to say that this pact is just creating misery and it's not in line with the values of the EU and the standard of living within the EU. So the left group will now come up with an alternative suggestion in order to take up the challenge of migration and asylum. So we are now going to try and put forward an alternative proposal for more solidarity. And I believe that we should not only look at the technical aspects related to the Migration and Asylum Pact. This is also a political issue, and that's why we are all united as comrades in the left group. I think we want to defend the dignity of those people who are leaving their own country to feel safe. It was said by the speakers in the first roundtable, the reception conditions are inhumane. There are clear infringements of human rights and clear hypocrisy also. And I believe that the member states of first entry are now taking up all the responsibilities. So I think it is a shame to talk about the principle of solidarity. And those who are actually at the source of the problem are now talking about a problem related to a lack of solidarity, and they are not providing support to the member states of the first arrival. And policies put forward by the European Union are not a solution. But of course, we can not only criticize the pact, we also need to put forward other proposals, alternatives. So beyond criticism, we also need to take initiatives. And I believe it will be important to talk about dignified relocation. We need to promote the rights of asylum seekers. We need to achieve a system where we have a fair relocation. And this cannot be an excuse to fail to respect the rights of asylum seekers. And of course, we also need to help member states of first entry. Cornelia said it quite clearly. The Frontex director needs to recognize that. Of course, he's not alone, but he's representing the actions carried out by Frontex. Now, as Cornelia just told you, we're now going to start a second roundtable. Each speaker will have 5 minutes, and I would suggest we start immediately. And I will introduce the various speakers one by one. So I would like to turn to the first speaker. And that's Catherine Woolard, the Secretary General of ECRE. So Catherine, you have the floor.
Thank you very much, Chair, and thank you for the invitation. As ECRE, we agree very much with the analysis presented by the left group, and we also support your search for alternative proposals. As the subject of this panel is the way forward, I'd like to note 4 elements that we would suggest as part of a way forward, and happy to hear you and other panelists on whether there could be collective work. First element of the way forward would be defensive work on the pact, both legal and political. Legal work means proposing amendments to the legislative proposals that accompany the pact. We will shortly publish our line-by-line analysis and suggestions for change. The reason we're doing this is not to improve the legal quality of a set of proposals that is already legally dubious. We don't support the pact, and we're not suggesting amendments in order to make it more palatable. However, first of all, if the proposals are accepted, it's better that that is in an amended version, for instance, with basic guarantees added. But I think more importantly, engaging in the detail, exposing what's actually in the legislative proposals should lead to more opposition. And here I refer to the changing dynamics at the European Parliament. In particular, with the radicalisation of the EPP, there is probably no chance that the Parliament reaches progressive positions on these proposals. For that reason, it's important that all the progressive groups and the centre groups adopt clear red lines and refuse to agree to a Parliament position that breaks these red lines and that would undermine the right to protection in Europe. We know that the left group is solid on these issues. In other cases, the groups may be wavering more. And I think exposing the detail will also make sure that international organizations, for instance, also come out firmly on the problematic elements of the pact. The second element is to resist measures that are already being taken forward before agreement has been reached. The pact is a proposal. The 2 co-legislators now need to play their role as set out in the treaties. But we see the Commission acting as though this has already been agreed. And this is something that needs resistance. So for instance, I would highlight the situation in Greece, where experiments continue to be rolled out, but also external cooperation, where around 25 partnerships are already under preparation. This is an attempt to control external policy or to create a parallel external policy. Our suggestion would be that DG Home, Internal Affairs Commissioners and Internal Affairs Ministers stay in their lane, as the kids say. There is also an ongoing attempt to control external funding. Third element of the way forward, an insistence on compliance with the status quo. So the left group has very well highlighted the erroneous narratives that accompany the pact. I would add one more incorrect assertion, the idea that there is currently no asylum system. There is. While the pact is being negotiated, we're not operating in a vacuum. This is an area of EU competence with extensive detailed legal framework. And we need to not just focus on the pact, but not be distracted by the pact, to continue to insist on compliance with standards on reception, decision-making procedures, and so on. And this includes ending impunity for the flagrant violations that are taking place. And I think this is also a question of how Commission and EASO resources are used, with resources to be deployed also to ensure compliance with existing standards, rather than being channeled into endless attempts to reform in a way that undermines standards. Fourth and final element of the way forward, we would suggest, is to keep up this presentation of alternatives. One of the false narratives is that this pact is the last chance for an EU solution and the only option for an EU solution. This is a line that is being presented in order to try to get more pro-European member states and political groups in the Parliament on board. But it's also not the case. The status quo is there, it's far from perfect, but it can be improved. And we can all put forward our alternatives, as ECRE has already been doing. Compliance, not reform, with the exception of the responsibility sharing and Dublin piece. In the absence of the deeper reform of Dublin that we all know to be necessary, solidarity mechanisms, responsibility sharing through measures to support relocation after disembarkation, for instance. And then beyond that, the flanking measures, the safe and legal channels, inclusion through rights, respect and regularization, and then a foreign policy that is actually based on trying to prevent displacement in the first place. And thank you, I'll leave it there.
Okay.
All right, thank you. Thank you very much. I would like to hand over now to Alina Liapina. You have the floor. Alina.
Thank you for inviting me. Yeah, I think we've heard an extensive analysis of this disaster pact. I have nothing to add, basically. And we think in order to challenge it, building up on what Catherine just said, we need a convincing narrative on how a European migration policy should look like. In that sense, we in Zeebrugge believe that the municipal solution could be one of the key instruments. In the last years, hundreds of cities and municipalities across Europe showed their willingness to take in the refugees. In Germany, we have 200 municipalities. And in the Netherlands, for example, we have 180 cities that are ready to receive the people fleeing to Europe. In Germany, again, we have 3 federal regions, Berlin, Thuringia, and Bremen, that are willing to launch their own reception programs for the relocation from the EU border regions, but they are currently blocked by the German Interior Ministry. Apart from that, we have dozens of cities in Belgium, also known as hospitable cities. We have cities in Spain, Italy, in Switzerland, even in Austria, that wish to express their solidarity with the people on the move by taking them in. And the list is frankly growing day by day. What it means is that those cities have the necessary reception capacity to, for example, help the municipalities on the Greek islands to alleviate the difficulties, the hardships they're dealing with right now. And this is an example where we can switch the narrative. I talk about real practical solidarity that is missing in the proposed pact. Because solidarity-based voluntary receptions of people seeking protection can actually ease the plight at European border regions right now. Talking about moving forward and about alternative solutions, we think we need to start by evacuating people from the border camps right now. And those in need should only have to stay at the European external borders for the shortest possible time, and in a few days they should be brought to the willing host municipalities across Europe, and the non-refoulement principle must be respected, of course, and no one should be left behind. Down the road, we really need to focus on viable human rights-based relocation solutions, and there we need to make use of the municipal reception and local capacities. And it is not enough, we think, to say that cities should be able to launch their own reception programs. The EU institutions, including the Parliament itself, should actively strive to set up a direct humanitarian relocation programs from the border camps directly into the willing host municipalities. And maybe the last point, but it is actually very crucial. Instead of funding the deterrence operations of Frontex and the Libyan militias, we need to redirect and increase the EU financial support to the welcoming cities, the welcoming regions and countries. And the European institutions should provide direct and very simplified access to EU funds for reception and integration for the receiving municipalities, so that they can first fulfill their humanitarian obligations, and actually we can strengthen them as equal and prosperous communities in general. And I think I will stop here for now.
Ευχαριστούμε πάρα πολύ. Θέλω απλώς να συμπληρώσω ότι η κατάσταση που έχουμε...
Thank you very much. So let me also say that in these detention centers, well, we can see conditions similar to concentration camps. These conditions are very poor, and we are lacking information about this. And these citizens, these people, are becoming invisible also because of the pandemic, and because there are refugees over there, but also other people. And I think that this pact is making things even more dangerous. Let me now give the floor to Marie-Naz from Sea-Watch, and you have the floor for 5 minutes. Thank you very much.
Thank you very much.
Marie-Naz, you have the floor.
Yes, thank you. Good morning, everyone. Thank you very much for having Sea-Watch to briefly give an update and an impression to this discussion with regards to search and rescue in the Central Mediterranean. In addition to what Inma shared in the first panel this morning, I would like to give you an overview on our situation at the moment briefly. In the last weeks and months, we were only partially able to resume operations. Our airplane Moonbird was only able to fly 7 missions in October due to criminalization measures by the Italian authorities. And as you probably know, both our ships, the Sea-Watch 3 and the Sea-Watch 4, are currently blocked in Italy, and also by Italian authorities, as they state that our vessels are not equipped to conduct search and rescue. So they basically use port state controls since this spring already to prevent civil society from operating in the Mediterranean. And also we were only able to fly a few missions in October. We still spotted 217 persons in distress. And in these missions, again, we witnessed the involvement of UNAFOR-Med aircraft in pushbacks to Libya, and the unresponsiveness of a merchant vessel flying the Italian flag, the unresponsiveness of Italian and Maltese authorities, and the inability to reach the so-called Libyan Coast Guard in a moment of severe distress. So these circumstances, as you all know, lead to push and pullbacks of people to Libya. So maybe, again, what is important to underline over and over again is that we really have to express again that the deadly consequences of European migration and border policies can be witnessed every day. The systematic non-assistance of European member states and the delegation of rescue operations to the so-called Libyan Coast Guard, the unjustified and systematic delays by European member states to fulfill their obligations to conduct and coordinate sea rescue in their respective search and rescue zones, and the need for NGO vessels, obviously, in the Central Mediterranean in order to uphold the law and save human lives. Yeah, what is pretty obvious is that the pact does not change one single point of this reality, but on the contrary. So for us also, it is very important to underline again and again that what we as civil society witness at the EU's external borders and what can be understood as the core of the European migration regime is a truly racist and neo-colonial approach. And the European Commission, the member states and parts of the European Parliament transform their racist convictions into policy, which can be seen in the Migration Pact at basically every single proposal. So when we were reading through the pact, it makes us again speechless how racist the narrative is, as well as how openly the finalization of the Fortress Europe idea is promoted. Yeah, speaking concretely, I mean, a lot has been said on specific aspects of the pact already. So I will just concentrate on a few points with relation to search and rescue, apart from the important points Inma made already. So in the so-called SAR recommendations of the pact, we clearly see that the current practices of Italy to prevent NGOs to operate are aimed to be taken as the new European approach. So what does it mean? Like the recent practice of port state controls, which is, important to say, a legitimate control mechanism for safety on board, of course, but it's nowadays used by Italy in a manipulative manner in order to prevent search and rescue vessels to conduct search and rescue. This approach can be found in the SAR recommendations as well, in which it underlines the need to ensure that vessels are suitably registered and properly equipped to meet the relevant safety requirements. In this regard, it is important to underline that this basically goes against international law, which is based on the assumption that in a distress at sea, any ship is capable of rescuing shipwrecked persons. So yeah, to sum up, nothing good will come out of these recommendations. We clearly see this as the attempt to harmonize safety regulations, and this expresses a new way of the European Commission and the member states to make it difficult for civil society to be present in the Mediterranean. And for us, this means in practice that we go against the violation of port state control principle by Italy and submitted court appeals for the blockade of the Sea-Watch 3 and the Sea-Watch 4, as well as in the context of the grounding of our airplane. Yeah, of course, we try to be operational as soon as possible again, and we need any possible public support for this. And also, like on a more technical level, we are also in touch with the German ministries representing our flag state to get as much information as possible on the contact group, which is formed by the European Commission in the context of the SAR recommendations. Yeah, because there they try to come up with guidelines of member states to better coordinate and harmonize safety requirements. So we are very worried about that development. Yeah, I mean, I think our core political demands, they stay the same since years. So I rather concentrated now on giving you a brief update on our situation, rather than repeating what we demand from policymakers. But yeah, I think this is transparent and visible everywhere, what our core demands are. Thank you.
Σας ευχαριστούμε πάρα πολύ. Ερχόμαστε τώρα στην πολιτική μας ομάδα, στην ομάδα της αριστεράς. Παρακαλώ τη...
Thank you very much, Marinas. And now we will move on to Sira Rigo from the left. Sira Rigo, you have the floor. Thank you. Thank you very much. It is a sheer pleasure for me to hear you today, and I would like to thank the different people who helped organizing this meeting. Thank you for sharing all these very important elements. This is a very long process. Several decisions have been taken by the Commission, and now we have to see how we can pave a way forward, pave a way on such an important topic, which actually reflects the worst values from the far right, from the European institutions. And I think that we should focus on the mid-term and the long term as well. I think we have a proper framework in Europe, and now we need to see how we can build a common sense there, how we can build a discourse on migration, and all our organizations, all of our political families need to play a role to make the consensus evolve. And I think that we should repeat our message over and over again so that we go against, well, the concept of landsliding, because the International Migration Organization says that there are fewer and fewer people arriving in Europe, and this is wrong. What's happening today is a direct consequence of the migration policy in Europe. We also need to stress the fact that there are some blocking policies which make people vulnerable over and over again, that fundamental rights are violated over and over again. And we also need to stress the fact that we are responsible for this, and we should also stress the consequences of colonialism, multinationals, and the conflicts which lead to migration flows. We are part of the problem, but we should be part of the solution. So we need to build stronger narratives. We say it, we need to defend human rights, and we say it for several very good reasons. Furthermore, we have several proposals. I have listened to all the colleagues, and I do agree with many things which have been said, and I will say that indeed we need to explore all the legal means to avoid deaths and to protect fundamental rights. Secondly, we need to neutralize organized crime with a legal framework. We are fed up with criminalizing those who try to support people who try to find a better future, and we want to support people who try to support other people at sea. And we've heard the director of Frontex. He's a racist, and he considers that anyone who tries to find a better future in Europe as a threat, and the militarization of the EU is also a major issue we need to tackle with civil society. Then the question of international warranties and international protection is paramount to me, and we need to share and pool resources. Europe has enough resources, economic resources, financial resources, to have supporting policies and not militarization policies or blocking policies. If Frontex's policies were really supporting policies, well, then the situation would be completely different. We have enough resources to avoid conflicts and frictions between different countries in the EU. So thank you very much. Thank you, Sira. Thank you so much. I think that you indeed raised the important issues. And from what we've heard from the different speakers, indeed, we do understand that it is possible to create a narrative to change the situation. The Greens, the Socialists, and the left need to take their responsibilities. The left tries to play its role, and now let's move on to Sweden, from Spain to Sweden, and let's listen to Malin Björk. Malin Björk, you have the floor.
Hello everyone. I'm very happy to be here for this whole seminar. I will I divided the things, if looking at the way forward and I agree to Catherine Woolard from the ECRE that we have like a short-term and a long-term perspective maybe in this. And unfortunately, the short-term perspective then is a lot about damage control maybe, and trying to avoid the worst to happen. But it is our duty, as least as when you are having a mandate in the European Parliament, that we have to take very seriously, and we do indeed. So then I want to thank the panelists in the first panel for your analysis, and that we have to continue to dig deep into to every line of this proposal in order to have, as the analysis becomes deeper, we also make it visible that this is an impossible way to take, and this will be very valuable for convincing to have a majority that can stop these proposals. And that's why it's so important with your analysis in the first panel, everything from the pre-screening we have to target those suggestions, the issues of detentions that will become systematic, the kind of legal meltdown and insecurities that are built into the system that have been highlighted, the way solidarity is being completely baffled in terms of deportation, being formulated in terms of deportations and externalization. Also looking at what was raised by Sara Prestiani about externalization in terms of what's happening there, not only in the field of migration, but that it also, of course, spills over to how development policies are formulated, both at EU level and at national level. So that's the short term. This is our short-term work. And in order to be effective on that, we have to have this seminar here, and I want to thank our colleagues that have called that together and everyone participating. This is part of that, to build between NGOs, researchers, people on the ground, political decision makers, to make sure that we have our, we get all the muscles together and the brains together and all the energy together to be able to do that short-term work that is engaging in the pact and stopping those elements and making sure that we reroute. And if I look at the longer run, things have been highlighted here already, but I do think that we are so often caught with this short term, like trying to avoid the most horrible situations and suggest political proposals, that we don't challenge enough, or we don't take enough time to challenge the narrative. We're just caught up in trying to resist, in our case, in the parliamentary spaces, in your case, in the ground, the kind of spread of racism and securitarian maneuvers. So, but we have a responsibility to focus also on the narrative, on offering the other solutions and the other story about migration and asylum seeking, and what kind of continent we want to be. And it also means that we have to bring, maybe heighten the issue of international law, but also taking into, the very, very political aspects on who distribution of wealth and trade relationships, development aid, etc. And that we have to have a broader picture. And also, in that sense, I think we also have to then have our vision of European policy, that where we put the focus on, the good examples. Solidarity will solve this, nothing else. And I think the fact of looking at good examples of relocation, but also, it was said in the first panel, it hasn't always worked, of course, the decisions that the council took. So what are the problems? But how could it work? Because it could work. And I think Alina's suggestion on European programs that tip in just as much money in supporting those regions and cities, for example, that want to do solidarity twinning. Why isn't that program existing? So we have to have these very concrete and positive programs put in place where the money also goes. Which brings me to the money. I think maybe sometimes also we focus too little on the money. This whole MFF, I work a lot on the issues of democracy, rule and law, but they are very connected. to the securitarian approach and the militarization that we see of the EU. So we should be very, very vigilant about EU money, because it's also shaping the way member states spend their national money. If the whole European money flow becomes more and more securitarian, more and more militarized, member states follow. So they are also being trapped in this. So we have to look at the money. We have to. People have pointed it out. We have to decouple these conditionalities that are inserted in the relationship to third countries, in trade agreements, in development aid. That has to. We have to put our nose there, and we have to be able to work with our member states to try to stop those developments. And I also want to highlight what Sea-Watch here and Marie said. When we have a society that criminalizes solidarity, be it search and rescue, be it NGOs, as Milena was speaking about the situation in Croatia, then we are on a very, very dangerous slope of how our societies are going to be shaped. So at every moment when solidarity is being criminalized, we have to be there, and we have to stand up, and we have to maybe sit down and say, this will be our action plan. When a ship is being, when it's being blocked in a port, this is how we will do, ABC. Those parliamentarians will go there, and we shouldn't let this just go on and deteriorate even more, because it will affect the whole of society. I will just say, to finish by saying that once when I worked with the anti-militarization issues in Sweden, they send northern Sweden is becoming this playground for military exercises for different countries. So they sent 10,000 militaries to train there. And then somebody said, okay, I'm already against it. But what at least they could send at least 10,000 diplomats at the same time to exercise a little bit, to train themselves in diplomacy and peaceful solutions, if they now find it useful to send 10,000 militaries. And I think that is useful to think. So we had Frontex in our committee yesterday, and he's putting, this Leggeri has to go, but even with him, even if he has to go, Frontex is a monster. 10,000 people are going to militarize our borders. Where are the 10,000 solidarity workers? That must be part of our political demands. Where are the 10,000 solidarity workers? It cannot be that we have chosen that route while we have closed the other door. It is our job to open it, and we will do that by all the possibilities we have in European Parliament, and we will be doing it with you. Thank you.
Ευχαριστώ πολύ. Μάλιν, να είσαι καλά. Πολύ σωστές οι επισημάνσεις, πολύ χρήσιμες οι επισημάνσεις της, Μάλιν. Και πάμε στον αγαπημένο μας.
Thank you so much. And let's move to Miguel Urban from Spain. Miguel, you have the floor. Thank you very much, Costa. First of all, I would like to thank all of those who made this webinar possible, and especially the people who worked on the study which is presented here today at this webinar. Thank you. Thank you for working on the reports, on the study. This data is paramount in order to face the current policy. We have seen how the far right has been able to create this policy, and I think this is a very interesting example which shows how policies are carried out. And I'd say that this has had consequences on the liberals, but also on the socialists. We have read several fake news on the participation of NGOs, and in Moria, and a socialist MEP asked a question on criminalizing some NGOs. After hearing some declarations in Germany on refugees. So that's the current situation. We've seen that all of this is defining the migration policy in Europe and this pact. This is a source of worry because mm, the European left is more and more isolated. We are alone there in order to try to defend a policy which really defends human rights, fundamental rights, a policy against militarization and criminalization of humanitarian aid. I think it is paramount to recognize this and to understand how since the beginning of um, this this mandate, well, things evolved. We've seen how things changed since left Lesbos with the migration policy in Europe. We've seen how some colleagues went to the Canary Islands to see the situation from their own eyes, and well, we can see that after Lesbos, Morias, and the Canary Island, nothing is becoming better. And these policies, which were actually already executed in 2006, are today crystallized. And today, the Canary Islands are used as an example of open air prison. We've seen how the Spanish governments act, but the first mission of Frontex was, well, to manage the crisis of 2006, and we saw how things accelerated afterwards and how fundamental rights became more and more violated. We have also seen how things happened in Greece, in Turkey, and now, well, we are in the Canary Islands and we have all these policies with the military, with, yes, open air prisons. And all of this, beyond the migration pact, well, worsens the situation. And as a consequence, we should try to see how we can fight this migration policy. I think that nowadays we are not favored, to say the least, within the European Parliament, and as a consequence, we need an alliance with political associations, but also with CSOs, in order to build a movement such as Welcome Refugees, which then changed and say, don't come to Europe, because of the European institutions. And so I would say that the fires from Moria, which were photographed, touched many people in Europe, and we don't want a second Moria. But how can we use this within these institutions and within civil society to have more mobilization and to make the common sense grow bigger, to share our discourse, because today we see this political agenda of the EU which is not in line with these values. And when we have a look at the Migration Pact, I think that it is important to focus on the debate with the Commission, but also to have a debate on the ground in the member states, because the member states will then adopt or not this Migration Pact. I think it is important to have more pressure. Some governments can say no to this pact, and actually, as was frightened to see the proposal from Italy, Spain, Malta, and Greece on the migration controls, because in actually the situation is even worse than what the Commission put on the table. Therefore, I think it is important to have a discussion, a debate on the ground in the different territories, so that we can have more pressure on the governments how do you want to put pressure on the Greek, the Italian, or the Spanish government? Well, the same way it has been done in France. Macron was the prince of the neoliberal Europe, and today is the prince of far-right policies. He used police forces in order to empty refugee camps in Paris, and today we need to act. And I think that this is fundamental, and we should think about that. Thank you very much, Kostas.
Thank you very much. I'd like to thank you, Miguel. I hope I didn't interrupt you too suddenly, but I would like to ask Catherine to get ready because I received a question addressed to her. So there will be a question to Catherine at the end of this second roundtable. And it's a question about children, about detained children. So, Catherine, I would like to invite you to get ready to answer that question. And I would like to invite all participants to write down your questions in the chat, and it might be easier for you to tell us to whom your questions are addressed. Thank you. And I'd like to give the floor now to Fernando.
Thank you, Kostas. Good morning, everybody. Hope you are doing well. Well, as some of you will surely know, some GUE NGL MEPs visited Lesbos last September and had the opportunity to meet on the ground a complex reality that shocked us all and made us even more aware of the need to confront the pact on asylum and migration that condemns migrants to be packed in such a black hole in the external borders of the European Union. This is not something happening just in Greece. Italy is also hosting these camps, Lampedusa and some others, and Spain is reacting the same way as Miguel said before by setting up Moria-style camps in the Canary Islands. May I say that some members of the left group in the parliament will be paying a visit to the Canary Islands as of tomorrow. The new pact on asylum and migration will have to be discussed and processed in the European Parliament, and the left group of the Parliament will defend that any European policy on this matter should be based on the right to migrate as a human right and the respect of human rights, one of the main inspirations, as they say, of the European project. You already know that the Commission's proposal has failed to provide, first, a realistic approach to the issue, and second, they have shown no power nor commitment to confront the Visegrad countries' ultra-right-wing stance as regards to migration. And this is the real and nefarious starting up of the several acts of the referred proposal. It's particularly easy to criticize the Asylum and Migration Pact proposal if you come from being supportive of the due respect to human rights on the left side of politics, but it's not particularly easy to offer alternatives from a realistic approach. And I would say that the left group in the parliament has just delivered a document, as you know, in which we try to act on a realistic way and deliver real alternatives. In that document, we're asking for fast border procedures. We're asking for the end of pushbacks and proper law enforcement by Frontex, a binding relocation mechanism of distribution of asylum seekers across the Union, dignified reception conditions for those arriving to the European Union, no more Morias, no more camps, open, safe, and legal channels to the Union, a Union-funded search and rescue and the end of criminalization, and an overall approach to the issue based, as I said before, on the respect of the right to migrate as a human right. The particular lacks of the new pact delivered by the European Commission have been clearly shown by the panelists that took the floor before me. I will not take any longer, but I just want to say that bringing to an end the Dublin system is crucial in order to start making things properly and human rights accountable. There is no possible solution, and this must be repeated 1,000 times. There is no possible solution under the current Dublin regulation. We urgently need safe paths to the member states chosen by those arriving to the European Union, and a mandatory relocation scheme all around the European Union. I will say that these points mentioned are just the basics, and we will confront the new pact initiative according to those principles in the future. Thank you very much for your attention.
Εμείς ευχαριστούμε. Θέλω να σημειώσω ότι και οι συμμετέχοντες...
Thank you very much for this contribution. And I hope, and I know the participants and speakers of the roundtable are still with us, so they will be able to participate to the Q&A session. So I think we have been able to stick to the time we had, and I would like to come to the first question that was asked in the chat. This question is directed at Catherine, but of course, should other speakers want the floor, it is a possibility, but I'd like to hand over now to Catherine.
Yes, thank you. So I understand there's a question come in on detention of children. ECRE's position is to oppose detention of children under any circumstances. We don't accept that there could be any legitimate reason to detain a child in a migration context or in any other. And that is primarily through reference to the principle of the best interest of the child, which is a key principle in international law and specifically set out in the Convention on the Rights of the Child. And I think if we look at the situation in Greece, the commentator refers to children being held in police stations. ECRE has condemned this, and we continue to do so. In fact, we every year in our AIDA report assessing the asylum system in Greece, we continue to highlight that it's unacceptable that children are kept in police cells in Greece due to lack of decent reception, adequate reception conditions. Let me conclude by just noting that others have, the pact creates a situation where detention is inevitably entailed by the screening regulation and by the APR, the border procedure element of the procedures regulation. This is not stated explicitly, but the rules create obligations on member states that mean that detention will follow. And that will either be formal detention according to national law, or in many cases it will be de facto detention, which is almost worse as a situation because it's essentially detention but without the procedural guarantees and safeguards for the people detained. So we both oppose the use of those measures and then also argue for clear exemptions in all circumstances for children from detention, but also for families. The current exemptions are not wide enough and are not clear enough. All vulnerable people should be exempted.
Ευχαριστώ πάρα πολύ. Κάτι ψέλισε ο κύριος Μηταράκης μετά την πρόσφατη έκθεση από το...
Thank you very much. Yes, we fully agree with you, and Mr. Minos Mouzarakis talked about this report, and indeed there is a clear problem in the Greek islands. There was also a problem mentioned about the agreement concluded with Turkey, as it was highlighted by Miguel and other speakers. Now, I see there is another question about the Canary Islands. Apparently, some regions would be willing to receive and welcome migrants, but central authorities are refusing. How would it be possible to introduce a decentralized reception policy? Now, I do not know if there's someone who would like to answer this question, because I do not know to whom it is addressed. Maybe Sira would like to answer this first question. Yes, so the question is to know how we can introduce a decentralized policy. Well, I believe it is important first to have a general approach, a global system that will be based on the respect for human rights, of course, as it was said before during this roundtable. And afterwards, it would be important to see how we can provide support to the regions that are directly impacted by the flows and arrivals of migrants. But would it be possible to repeat the question, please, or to clarify the question? Thank you. Yes, I think that Fernando also talked about Canary Islands, and some regions are willing to welcome migrants, but central authorities refuse that. So how can we actually introduce a decentralized system for the distribution of migrants? Thank you very much. Yes, we are currently negotiating general framework, and
Create
yesterday
obligations on member states that mean that detention will follow, and that will either be
several
formal
transfers
detention
to the center of Spain were announced. Several transfers and in the government, we have two political parties in the coalition. The agendas are different, the priorities are different, so we need to negotiate. For us, the most important part is to find a solution to these migratory flows. And we are currently working on this. We're trying to achieve a system where we can actually distribute the migrants fairly according to the criteria mentioned this morning. Thank you. The migrants fairly according to the criteria mentioned this morning. Miguel? Yes, I would like to come back to the issue raised by Costas. As Sira just said, the migratory policy is a socialist-based policy because they have the hold on the Ministry for Migration, the Ministry for Home Affairs and Foreign Affairs, and socialists prevented the redistribution of migrants to the Canary Islands. So Canary Islands became open prisons, and the European Commission had to intervene at one point. And they had to repeat that the EU was not trying to prevent the free movement for these migrants within the European state. So these migrants can be fairly distributed on the Spanish territory. There's no problem about that. And this distribution might attract other migrants. And as Sira and other speakers said, some socialist parties are actually buying in the popular narrative, the extreme right, the far right narrative, saying that if the system is improved in Spain, it will attract even more migrants. But if the system is improved in Spain, I believe that the Spanish state has to find a solution to this crisis. But of course, Spain should not be isolated. Other member states should also find these solutions. There should be reception centers throughout the EU, and we should not only focus on the redistribution of migrants within the Spanish territory. Other cities and municipalities around Europe would be willing to welcome these migrants. And the Migration and Asylum Pact will actually prevent those transfers and this redistribution. And all, according to the Spanish minister, people reaching the Canary Islands are people who would not be entitled to asylum. In 80% of the cases, they are talking about economic migration only, but I believe that the socialist political party is really adopting a far-right narrative. 3 years ago, they welcomed the Aquarius ship. And this socialist party 3 years ago had a totally different migration policy compared to the Salvini policy in Italy. And the Socialist Party is now giving up and adopting the narrative of the far right. This is something we have to fight against. All right, thank you very much for this intervention, Miguel. We still have about 15 minutes, so I would like to seize this opportunity to thank interpreters who are there to support us and help us despite the pandemic, and the interpreters would like to thank you too. And I would like to make a comment about the discussions around the agreement between the EU and Turkey. I believe I've already had the opportunity to express my views about this agreement. We need to denounce this agreement. It is based on blackmail. And here I see another question. What will happen to asylum seekers who are detained in the reception centers in reception countries? Cornelia, you have the floor.
Okay. Ja, vielen Dank. Ich wollte eigentlich etwas sagen.
Thank you very much.
Okay.
I wanted to say something about the relationship between regional governments and the federal government, as is the case in Germany. We have about 200 municipalities and districts that would be willing to receive various refugees from the Greek islands. And they would also have the capacities, the money is available, the spaces are there, everything is there to help these people now ahead of the winter. Everything is there to help these people now ahead of the winter. Our Minister for Internal Affairs, Mr. Seehofer, who's also very much present in the council, well, he's the one prohibiting this. So we in the left co-govern in Berlin. Well, he's the one prohibiting this. And we are now suing the federal government in Berlin to ensure that countries that want to receive additional refugees on a voluntary basis can also do so without having to wait for the green light of the Minister for Internal Affairs. That's our situation, and it affects many municipalities and cities that would be able to take up a lot of refugees and would be very happy to do so and also have the funds for it. And German politicians are preventing from movements happening here, also within the council. The last package, the asylum package, was also blocked due to Mr. Seehofer, who has a very reactionary position and supports the extremists on the right side of the political spectrum with his opinion. Extremists on the right side of the political spectrum with his opinion. Extremists on the right side of the political spectrum with his opinion.
May I respond to one of the questions, Chair?
Vielen Dank für diese Wortmeldung. Dann hat Catherine das Wort.
Yes, thank you very much. I saw there was a question from somebody called Hala in the questions and answers, which looks at the question of those with protection and those migrating for other reasons. And I wanted to make a few comments on that. We don't agree with attempts to stigmatize people who are migrating for any particular reason that might lead them to leave their country. And I think we do want to emphasize that most people arriving in Europe currently do have protection needs. And they will get a positive decision at the end of a legal process, recognizing that they have protection needs, be that refugee status or subsidiary protection, or awarding a humanitarian protection status. The reason we emphasize this is because there's a lot of myths on that issue, and it's used to justify restrictive measures. So first of all, it's just a factual question. And I think people arriving, whoever they are entitled to a fair procedure, and a border procedure is not a fair procedure. We also know that there are people who have protection needs where this is not recognized by asylum systems just because decision making is not working properly. So even those who get a negative decision, there may be protection questions. Beyond that, we see people who are forced to migrate, but for reasons that are not covered by international refugee law, because it's rather out-of-date framework. All of that leads us then to the conclusion that a strategy that's based on stigmatizing people who don't have protection needs is highly flawed. For anybody, even if after all assessments and judging their circumstances, they're found not to have protection, of course, they have human rights, and international human rights law and EU human rights law under the Charter still applies. The final point I would make from ECRE's side, because sometimes it's suggested to us that we only focus on refugees and forget about the rest. I think a strategy that says we will save the good refugees and forget everybody else is highly flawed. That leads to a general approach of restrictive, border-focused migration policy. It also leads to violations, and it, I think, generates and maintains the xenophobic narrative about people arriving. I think it's also a dangerous strategy. The chair just talked about the EU-Turkey deal. Now, the EU-Turkey deal, the people who suffered most are refugees. And this is one of our objections to the pact. The Commission claims it's about offering protection to those who need it, but we know that border closures and focus on irregular migration actually leads to more problems for people who need protection, because they are the ones often who have to use irregular routes to flee persecution. So even though it becomes much more complicated, I think questioning and disentangling this narrative that it's easy to separate and we should only focus on refugees has multiple, presents multiple problems.
Ευχαριστούμε τις επισημάνσεις. Θέλω να είμαστε λίγο πιο σύντομοι για να μείνει ένα μάζεμα. Εγώ δεν θα κάνω κλείσιμο, εγώ μόνο θα πω κάτι.
Well, thank you very much for this contribution. I'm not going to close our meeting, but I see there is another question. A question saying that in many places around Europe, the left and the right groups agree on the notion of security. The left and the right groups agree on the notion of security. If some of us share the ideas of extreme right parties, it's not possible. We cannot support that type of narrative. We need to promote solidarity, so we can never support these narratives. So, I know we only have a few minutes left, so I would like to give the floor to Marie and Alina, maybe, in order to close our discussion. So I'll hand over to you immediately.
Thank you. Just a couple of brief remarks. I think the question of the decentralization of the migration system is actually one of the key questions because right now the whole migration agenda is hijacked by the nation states, and the European Union was not supposed to be a union of the nation states. It is like that, but it is not how we want to see it. And I think how we need to address that is we really need to, in the European institutions, the European Parliament, really engage with the cities and municipalities in the public debate and really regard them as political actors in order to put pressure onto the nation states. Yeah, and I think one brief comment maybe on the resettlement. I think that was not stressed enough. The resettlement possibilities, which are already there, have not been exhausted yet. It is the case in Germany where they pledged 5,000 places, resettlement places. I know that the situation is similar in the Netherlands and other countries. And so far, a small fraction of the pledged numbers were resettled. And this is, I think, also an important part to stress. Over to you, Marie. This is, I think, also an important part to...
Thanks a lot, Alina, and thank you everyone for this interesting round. Yeah, maybe just one last sentence, and thanks also a lot to Hala, who really nicely outlined the very important question of narrative here. And I think this is also really, really super important that we always have in mind that we have to reclaim the narrative. And that we understand the border regime we are facing as a racial border regime, that we are dealing here with racial borders, and don't forget the overall picture of the policies we are facing. And I think part of the reclaiming of the narrative has also to do with the revealing of the continuously nationalist agendas Alina also spoke about, and also really to see how we can Europeanize the story again. And when it comes to search and rescue, of course, two things which are always paramount is, first of all, safe passage. It's so simple, and it's so urgently needed, and it's so important that we are not tired enough to really ask for safe passage. This is the most important thing we should really outline when it comes to the politically motivated dying in the Mediterranean. And then also maybe just to remind every one of us, when there was the first standoff of a ZAR NGO ship in 2018 in the summer, like I think there was really a shock within European societies, and the media attention was really high. And now this is common practice of our operations. So whenever we plan an operation, we count the days and weeks we have to calculate for the standoff we are facing. So we really need to have no conditionality for disembarkation and understand that we are so used to get used of a far-right approach, and I think this is really dangerous. We are so used to get used
εξαιρετική επισήμανση, κυρία Νάς, Μαρή, εξαιρετική, και βεβαίως εδώ...
Thank you for this clarification, Marie. I think that indeed we were shocked by what happened and by the presence of Ursula von der Leyen at the border between the EU and Turkey. So indeed we have to promote reintegration, resettlement. These are buzzwords that need to be used again and again. These are important notions that should be understood by everyone. Now I'd like to turn to Malin just to conclude. You have the floor. Understood by everyone. Now I'd like to turn to Malin just to conclude.
I will be very short. Yeah, I will be very short. We have little time, and also because I think This talks that we have had to do, both had today, both the first panel and the second panel, is actually a start of taking on the resistance to the proposals in the pact and building our alternatives from everything to the bigger narrative, to the positive suggested proposals that we have to carry together with our other forces, to changing, to making sure that we look at the money issues, the budget issues, and the externalization, and what the EU is doing in third countries. So that is maybe one of the issues that we have to develop a little bit, to look in how are we going to be able to monitor, because that is a challenge in itself, what the EU is doing in third countries and what their plans are. Sarah Prestiani said there are 25 or 24 partnerships being negotiated. We as a parliament, we're completely sidelined in that, and we have to try to look into that. So we have an agenda ahead of us. It's good to know that we will work on this together, and you sure have us in the left to do that work. It's good to know that we will work on this together.
Περνάντο, μετά ο Μικέλ, η Σύρα και θα κάνει κλείσιμο, το λέω από τώρα για να μην χάσουμε καθόλου χρόνο.
Thank you. Now I see requests for the floor from Fernando, and Cornelia will conclude the meeting. Thank you. Fernando, you have the floor. And Cornelia will conclude the meeting. Thank you. Fernando, you have the floor. And Cornelia will conclude the meeting. Thank you.
Sorry, I'm sorry. Μικέλ, εσύ, αμέσως μετά η Σύρα και κλείνει η Κορνηλία.
Miguel has the floor, then Sira, and finally we will have So, very briefly, two things I would like to say. I think we should not be pessimistic. I tried to read the conclusions of what we were reading here. I see people think we are a bit pessimistic, but I think we need to be optimistic and well informed. We need to know the situation to try to change it. I think it is paramount to try to have great alliances to change the situation. And furthermore, I think that the next debate we'll have before this pact is the question of conditionality to development. In plenary, we have seen how the Tobé report showed there was a strong alliance between a major part of the liberals with ECR, with far-right, and with EPP, to try to change the Tobé report and have a conditionality with development support and migration. So we will need more debate on this, on this topic, which is crucial. And I think we should try to have more and put more pressure with the left-wing organizations, with the green organizations, with the European Parliament, to try to avoid the adoption of conditionality by the EP, because this would be a cornerstone. And so let's do it, and let's put pressure on the authorities. Thank you. Because this would be a cornerstone. And so let's do it, and let's put pressure on the authorities. Thank you. So indeed, we should not be pessimistic, and we should be optimistic and put pressure. Indeed, you're right. So indeed, we should not be pessimistic. I will also be brief, and as a conclusion, I want to say that I will also be brief, and as a conclusion, I want to say that indeed we shouldn't be too optimistic. Indeed, we need to be optimistic, but we need to be realistic vis-à-vis the balance of power. And I think that today we can indeed show that migration can help us go forward and reinforce the EU. It's true that there is this far-right political agenda with an economic point of view, legal point of view, and that are some well-established interests. And indeed, this apparently seems to be nice, but we know it's from the far right, and we shouldn't think that we will be defeated. I think that with common sense in Europe, we will be able to pave a way forward, and that citizens and simple people will be able, well, to go ahead. We have this tradition of fighting for human rights, of fighting for ecology, for feminism, and I think that we need to rely on this to make progress. And indeed, we need to use all of this to make progress on the migration policy, so that we have a strong European bloc for a very different agenda. And I think that we should make more efforts, keep on and fight indeed. And I encourage you to continue fighting for it. Thank you. Thank you so much. I encourage you to. Cornelia, you have the floor. Thank you. Thank you so much. Well, thank you. Cornelia, you have the floor. Indeed. Well, thank you. We need to find alliances, and also with all structures who share our values at the Parliament as well. We need to work with all the members of the European Parliament, also try to develop dialogue and convince people so that they are opposed to this pact. We need to build majorities to put an end to this madness. There is no conclusion here, and I want to repeat it over again. We need you all. We need you all to go forward with the EP in order to table amendments, to work on the trilogue, to work after the trilogue, and we will have to raise awareness on the rights of asylum seekers, and we will also need to continue this battle. It's about our values. It is about our daily work, and well, we are ready to wage the battle, to do everything that is possible within the European Parliament with you, so that together we do it. I don't know where you're at, but we do need your support. It is essential, and that's why this webinar was paramount. Thank you. But we do need your support. It is essential, and that's why this webinar was paramount. Thank you. But we do need your support. It is essential. Well, thank you very much for your presence at this webinar. I would like to thank the organizers, the interpreters. Thank you, Mr. And I would also like to thank the different panelists who allowed us to have a better understanding of this topic today. And I want also to thank our dear friends and the people who shared this webinar on the social networks. Take good care, stay safe, and see you soon. Goodbye. The interpreters wish you a lovely afternoon. Goodbye. Take good care, stay safe, and see you soon. Goodbye. The interpreters wish you a
Thank
lovely
you. Bye
afternoon.
bye.
Goodbye.
Thank you all. Bye.
Thank you. Bye bye.
Thank you all. Bye.
Thank you. Bye bye.
Thank you all. Bye.
Thank you. Bye bye.
Jacques, c'est bon de mon côté. Jacques, c'est bon de mon côté. Jacques, c'est bon de mon côté.